Hello everyone, and welcome to our lecture recording for Chapter 5. Today we're going to look at civil liability and the law of torts and negligence. We are going to do that through our usual approach with the learning objectives for Chapter 5. So the first thing is to look at describing the law of torts, its general principles, and the statutes of limitations for tort actions. Alright. So to start with, on page 117 you'll find that there's an introduction that emphasizes the importance of this type of law, substantive area of law, especially for businesses. And you'll find that it says that there is a wide range of interests that this type of law, tort law, protects. Examples are given such as liability for the breach of duty to take reasonable care. So this is what we call negligence. We'll talk more about it today. Liability arising out of occupation or possession of property. Direct interferences with the person, property, or goods of another. Liability for misrepresentations, interference with contractual relations, and fraudulent misrepresentation and breach of statutory duty. Alright. So what do we mean by tort? Where does this word come from? The word really is from Old French, and it's related to English language words such as torque, and it basically means twisting or doing something wrong, in particular civil wrong as opposed to criminal wrong. So the idea is that we have this dichotomy or distinction between a crime, which would have remedies such as punishment by imprisonment or fines, and civil wrongs which would have remedies such as monetary compensation. So in a nutshell, a tort is a civil wrong. Two principles decide the ambit or the extent of this tort and what would be caught under such areas of law or causes of action. So what are these two principles? The first is what it says here: an act or omission by the defendant. So the defendant has done or omitted to do something that interfered with rights or interests of the plaintiff, thus causing damage. When we say damage, we mean something like hurt. So the first principle that attracts a cause of action in torts is that there was either an act or an omission by the defendant, and this act or omission interfered with the plaintiff's rights or interests. And because of that, we have to remember that there was damages. So the idea is that the plaintiff suffered some form of harm. The second principle on which this substantive area is based is the interference, is that the interference must give rise to a cause of action for damages. So once you have established that there was this omission or an act that interfered with rights and interests, then you have to identify what cause of action we can bring to courts in order for us to establish damages. And that basically means that you would be compensated in the sense that you will be paid a sum of money for the harm, to compensate you basically for the harm that you've suffered and that was caused by the defendant. When we say cause of action, we mean things like specific torts such as negligence, but there are also other things like trespass to person, or trespass to chattel, or things like nuisance and other economic torts that we will be referring to in much more detail when we look at chapter 23. Now, it's important for us to understand the difference between these three substantive areas of law. We have criminal law, tort law, and contract law. The first dimension that we want to look at is the standard of proof. What does that mean? So this is the level of evidence, the quality of evidence that you have to establish in order for you to make or to prove the cause of action against the defendant. In criminal law, the Crown, i.e. the state or the government, must prove its case beyond reasonable doubt. So this is a very high standard, so a very high percentage, if you like, on the probability of maybe 80% or more, a high standard. And the reason is, of course, the type of punishment. So if you look at the second dimension here, sanctions and remedies, under criminal law there will be punishment and there will be stigma in relation to finding against the defendant or the accused in that sense. In contrast, under tort law, you'll find that the plaintiff must prove their case, not the Crown. It's you. The burden is on you and your legal representative or representatives to prove that their case is beyond is on the balance of probabilities. So this is a much lower standard than beyond reasonable doubt, and we're talking basically about a percentage maybe like 55 or 50, even 1%. That should be enough to tip the scales in your favor and hence prove the cause of action, such as, for example, negligence against the defendant. And the reason for that this much lower standard of proof, first of all, it's not being done by the Crown, which has much more resources, but it's done by the private plaintiff, even sometimes if it is a company, because the sanctions and remedies that will come out of this are simply monetary compensation. Okay. Under consent, the third dimension, it says that under criminal law, whether the victim consents to the accused's actions is irrelevant. So you can't come and say that the victim consented to what I've done. So it's irrelevant because what you have done is a crime and you will be punished for it because of the act itself. Under tort law, the injured party can consent to the defendant's actions, and as we will see later in this lecture recording, sometimes that voluntary assumption of risk is actually a complete defense against an action of negligence, which means simply that if you have accepted the risk inherent in the type of actions that were carried out, for example, you're playing a dangerous sport, then you can't turn around later and say, I want compensation for the damages I've suffered. As to the role of the Crown, under criminal law, a convicted person can be pardoned. Under tort law, the Crown has no authority to pardon a tort short of legislating. So if they want to pardon a tort, they have to legislate actually for that specific incidence, pardoning the person who has committed the tort. Which is just a theoretical possibility. It will not happen in practice. Almost certainty it will not happen in practice. Now, the last two dimensions or rows are about promises and agreement, and this will take us through a different contrast now between contract law and tort. Under promises in contract law, contract law then is concerned with having the promises of others performed. So in contract law, we are basically creating rights and liabilities in agreement with the other party to the contract. Okay, and that's usually done through an exchange of promises, and contract law then becomes your tool or cause of action to make sure that those promises are performed. And if they are breached, then you can also go for compensation, monetary compensation, just like you would do under tort law. However, in tort law, interests covered are wider than contract law, and they cover both person and property. So meaning, In contract law, under contract law, the rights of the parties are created between themselves. In tort law, the rights are created for society at large. You don't have to agree to these rights. They are already there for you. You just need to know that they exist and that you can enforce these rights. The last dimension is about agreement. And under contract law, while contractual duty mainly comes from agreement of the parties, it can be imposed by law. Under tort law, tortious duty is imposed independently of the consent of the parties, although rights and duties may be varied contractually. Alright. Let's move on to our second learning objective, which asks us to explain negligence and the introduction of civil liability legislation by federal, state, and territory governments. One thing I want to point out before we move on to this second objective is what you have on page 120, and that talks about the time periods for tort actions. So this is what we mean by the statutes of limitation for tort actions. Okay. So in the risk management alert box, it tells you that injured parties must be aware that there are time limits set by relevant state or territory limitation legislation within which an action must be brought. Underneath that you'll find a table that gives you different limitations for different causes of action in different jurisdictions. Take for example Queensland. In Queensland we have the Statute of Limitations of Actions Act of 1974, and here you'll find that negligence has a statutory limitation of 3 years. Now on page 121 it explains to you that the date on which the time commences to run, that is the date that the injured party must commence the action, will depend on whether or not the tort is actionable per se without proof of damage. So there are some torts, and as we will learn later, especially under in chapter 23, there are certain torts that do not require you to prove damages, that you have suffered any harm, such as trespass, for example. So in torts actionable per se, for example trespass, time begins to run from the date of the act committing the tort. In torts such as negligence, where proof of damage is required as part of the cause of action, time generally begins to run from the date when the damage occurs. However, in cases of latent injury or damage, the courts have been given a statutory discretionary power to extend the limitation period. Alright, let's then move to our second learning objective, which asks us again to explain negligence. So this is the cause of action we'll focus on today, and the introduction of civil liability legislation, basically to limit your ability as a plaintiff to receive or to obtain monetary compensation under this cause of action. So this is what's known as the civil liability legislation, or the CLA Acts, in all jurisdictions. So we start on page 123, and we start identifying what we mean by this cause of action called negligence. Just flowing from the two general principles we discussed at the beginning, negligence is omitting to do something that a reasonable person would do, or doing something that a prudent and reasonable person would not do. And it is the failure to exercise reasonable care and skill. Let's then talk a little bit in relation to what's known as the IP report, IPP report, and this was basically a report to try and limit the problems that, or try to limit the compensation that was given under the common law cause of action of negligence. So on page 122 it says, in 2002 the Commonwealth, state and territory governments responded to what they perceived was a crisis over the availability and affordability of personal liability insurance by commissioning a review into the law of negligence to be headed by Justice Ip, including its interaction with the then Trade Practices Act of 1974. This is now, of course, what's known as the Competition and Consumer Act of 2010, both Commonwealth. So this resulted in a report, the Review of the Law of Negligence Report, or what's known as the IP report, and this came out in October of that year, October 2002, and resulted in all Australian jurisdictions making statutory changes to what had to be established by a plaintiff to succeed in a negligence claim. Not only making it more difficult for a plaintiff to succeed in a negligence claim, but also restricting the right of a plaintiff to recover damages. Let's then talk a little bit about the necessary elements required to establish negligence. So you'll find again on page 122 there's a summary of these 3 steps, and that's what we refer to as elements. And just a reminder that when I say elements, it means that these are necessary components of the cause of action, in this case negligence. So you have to succeed in proving each one of these elements in order for you to make the cause of action and in order for you to receive compensation, provided of course that the defendant is unsuccessful in raising any defenses that we'll look at when we look at the last step, step 5. So steps 1 to 3 on the slide are what we refer to as the elements of negligence. So the first one is that you have to establish the existence of a duty of care on the defendant. So you ask the question, does the defendant owe a duty of care to the plaintiff? The second one is establishing the breach of this duty. So you'd ask, has the defendant breached their duty of care? And the last one is, has the plaintiff suffered damages? Now, there's a good thing in your course, in your textbook, which is the flow charts that you will find explaining how these elements interact with each other. So the 3 steps or the 3 elements are shown to you in summary form on page 124. And the idea behind legal analysis, when you have a question or a scenario or a set of facts that are potentially relevant or potentially related to a cause of action negligence. So this is where you have to come in as a legal analyst and attempt to see whether the set of facts that you have can succeed on a cause of action, say in negligence. So this is what we call spotting the legal issue. We'll talk more about that when we come to our lectorials. But for now, let's focus on these 3 steps in this summary form. So the first step is asking us, does the defendant, D, owe P, the plaintiff, a duty of care? How do you go about answering this question? So there are more questions that you need to ask. The first one, was it reasonably foreseeable that the defendant's conduct could injure the plaintiff? And there are tests, legal tests, through which you can establish whether this was a reasonably foreseeable instance. The second question is, was there a vulnerable relationship, position of reliance? The third one is, are there any policy considerations that should prevent D being held liable to P? So these are 3 questions we go through in order for us to establish the first element, which is, does the defendant owe the plaintiff a duty of care? Always remember that we are required to provide evidence of each one of these steps in relation to a standard proof which is on the balance of probabilities. You have to succeed in this element, proving this element, otherwise your action is going to fail. Your action in negligence is going to fail. Let's assume that you have succeeded in establishing this element. The second element you have to look at is, has the defendant breached their duty of care? Again, a set of questions that we need to answer. First, was the risk foreseeable? Second, was it a risk which the person knew or ought to have known about? So this is basically the same question. Was the risk foreseeable? The second, was the risk not insignificant? So this is what we call double negation. So as if you're saying, was the risk significant? Okay. So usually in legal writing you'll find that they use a lot of double negation. So we would ask, was the risk not insignificant? The last question asks us, in the circumstances, would a reasonable person in these position have taken precautions? So these are the questions we need to ask to establish breach of the duty of care. Breach of the duty of care. Once we are successful on the second element, we move to the third one, which asks us, has the plaintiff suffered damages? Another three questions we have to ask. First, has the plaintiff suffered actual damage or actual loss? The second, was the damage caused by the defendant's breach of duty, thus causation? And was the risk reasonably foreseeable, i.e. not too remote? Okay. So these are the three elements that you need to go through and ascertain through the set of facts that you have whether each one of them is made on the cause of action of negligence. And after that you have to look at the defenses, whether there was a defense of contributory negligence, which is just a partial defense, meaning that it will proportion the damages paid to the plaintiff, or if there was voluntary assumption of risk, which would mean that you would have a full defense, which also means that the plaintiff will recover nothing. Okay. So this is the summary that we have on page 5.1 in relation to the elements of negligence and the three steps that we see here. Now remember that there are matters that relate to fact and matters that relate to law in the analytical structure or the legal analysis that you carry out under this cause of action. Okay. Matters of fact include things like resolving conflicts in the evidence. So the parties don't agree on the facts. Or evaluating the conduct of the parties. That's also a fact. And answer the question, did the defendant cause the damage and what was its extent? Okay. Causation as well would be a matter of fact. Now remember there are two types of causation. One of them is actual causation question, but there's also questions of remoteness, okay, or what we now call scope of liability, as we'll see later in a minute. These are matters of law, as well as establishing, questions of duty, and also the standard of care that would establish whether there has been a breach or not. All right. So let's expand a little bit on what we mean by existence of a duty of care. How do you go about testing the legal test to establish the existence of duty of care? So to determine whether a duty of care exists, the courts must determine the following. First, whether there was a reasonably foreseeable risk of injury, whether the cause is closely analogous to other cases. So this is what we call, this is what we meant by the doctrine of precedent. And if not, there are no established cases for duties of care. Look at the salient features of the case to determine whether they reveal a sufficiently close or a neighbor relationship between the parties. And this idea of neighbor relationship between the parties is something that we can see or talk more about when we look at in more detail the case of Donahue and Stevenson on page 125, 126. So that's really where the neighbor principle comes, and it's basically a statement by Lord Atkin that initiated really this whole area of negligence that we have today. The last thing that you have to look at in establishing this test for duty of care is whether there are policy or other considerations that mitigate against finding that a duty of care exists. We are unreasonable to expect that the defendant have done what was needed to prevent the harm. So this is what we mean by policy considerations, where there are certain economic factors, for example, that make it unreasonable to expect the defendant to have spent the cost or the money required to have prevented the harm that was suffered by the plaintiff. Alright, so we're still talking about these things in abstract, but we have to go through the abstract first, and then hopefully once we look at the cases in the electorals, we can put these things into practice, and you will be able to understand better how this thing works. So continuing still with the first element, we're saying that problems can arise in determining the duty questions where indirect harm or pure economic loss took place. So far we said that there are established categories of situations where we know, because of precedents, that there is a duty of care on the defendant to the plaintiff. So the examples are given to you on pages 126, 127. Okay. So for example, they talk about manufacturers of goods owe a duty to consumers. So if you buy something and it works in a way that causes you harm, think of, for example, safety features in cars. If you end up being involved in an accident and suffer damages, i.e. suffer harm, physical harm in the sense, because of the accident, and this was because of something that was wrong with the car, then you can go and sue the manufacturer in negligence. So basically saying that the manufacturer owes you a duty of care and they have breached that duty, and that breach cost you these damages, and you would go and ask for compensation for these damages, i.e. the harm that you have suffered from the accident. So things like, for example, medical bills, lost time of employment, anything that you can bring evidence to show that these costs resulted from the accident and the harm that followed. Employers owe a duty of care to employees, and the rest of the list you can find on 127, page 127. I'll leave that for you to look at. Now these are the established cases. So in an exam question, for example, or even if you hear a set of facts in your business environment, in your workplace, and it should immediately trigger in your mind that I don't have to worry too much about establishing the duty of care here, because we know that the duty of care exists based on the body of case law that we already have. Okay. Now the other side of the story is that there are also several categories of immunity. Okay. So this means that you cannot go and argue a cause of action and negligence on these factors, in these categories, and that's what we see on page 128. So that includes the armed forces, child protection agencies, barristers, and so on and so forth. Now we know that there are established categories, whether that there is a duty of care or no duty of care. Okay. Then there are these problematic areas where you have difficult questions that arise wherever there is harm that's caused indirectly, or where the harm was basically of a pure economic loss, not physical harm. No one broke their hand, but they lost profit, for example. And these two cases are talked about in relation to two cases, the Chapman and Hirsch case from the High Court of Australia, and you have Hedley Byrne and Heller from the United Kingdom from the Appellate Court, and those two are given to you on page 128. Okay, so here you'll find that in cases of psychiatric injury and also mental harm, the law has taken a restrictive approach to compensating people who have suffered no physical injury. So it's more difficult for you to be able to get compensation if there were no physical injury. But the law has been left with psychiatric or mental problems as a consequence. So if you've been suffering this mental harm in the form of psychiatric problems or in the form of mental problems, then you are going to have harder sort of burden or a heavier burden to establish this cause of action. Okay, and you have an example there given to you in TAME on that point. Okay, you'll notice also on page 129 that they talk a little bit about civil liability legislation, the Civil Liability Acts. We're not going to cover these in any much detail in this course, but we will refer to some sections that you are encouraged to go and look at. Here it says, unlike the common law position under civil liability legislation, whether the mental harm has been caused by a single sudden shock, okay, is a relevant circumstance that a court must consider when determining whether a duty should be imposed, but it is not the only consideration. Was the plaintiff at the scene, and what were the circumstances, for example, which led to the plaintiff being a witness to the victim being killed, injured, or put in danger? Or did the plaintiff have a close relationship with the victim? So remember, when you are doing legal analysis, everything starts with a question. So you need to ask questions and answer them through the analysis. Okay? And the questions are given to you in the analytical structure that you look at for each element of the cause of action. So as we said now, we have these three elements for negligence, and you have to go through the analytical structure just like we showed it in the flow chart. At the bottom of 129, we talk a little bit more about what's known as novel cases. Okay. Also on this slide, it says in novel cases, the courts look at the salient features of the relationship between the plaintiff and the defendant. And these are given to you in a menu list on pages 129 and 130. So these are not now elements, but factors. Okay? When we say factors, it means that you don't have to prove all of these factors, okay? Or you have to win on each one of these factors, but you have to win enough of these factors to show that these factors exist in this scenario, so that you can persuade the court to find a duty existing in this novel case. All right. So let's then continue with our second step. The second step can also be found in a flow chart on page 139. So we go to page 139 and we find that we are given this flow chart just like for the first step. And here you'll find, as we said before, you need to answer three questions. Notice that now you're given references to certain specific sections in the CLA Acts or the Civil Liability Acts. For example, on the first part, the content of the duty of care, on top of this flow chart, so under the step 2, was there a breach of the duty of care by the defendant? You'll find under the content of the duty of care, there's a section under the CLA Act in Queensland, which is section 9, that talks about this idea of what was the, or what should be the content of the duty. So the question to ask is, was the risk foreseeable? In order for us to see that there was a breach, we ask, was the risk foreseeable? Okay, that is, was it a risk which the person knew or ought to have known about? Okay. Note that when we talk about reasonable foreseeability in this step, in this element, we are, if you like, exiting the highway abstraction that we had in the first step. Because in the first step you saw that a lot of the things go with precedent. So there are a lot of established categories and so on. So it's a highway in a sense that you don't have to spend too much time looking at it. You can quickly establish whether there's a duty or there's no duty because it's an immunity category. And sometimes you'll have to go through the difficult categories where there is no physical injury or where you have a novel case. But this risk foreseeability, rather whether the risk is foreseeable in this analysis under the breach element, is more is less abstract. It's more about the actual facts in the case. So again, was it a risk which the person knew or ought to have known about? Okay. So when we talk about whether the person knew of this risk, we're talking about what's known as actual knowledge. Okay. The other one is known as constructive knowledge. So they ought to have known about it if you apply something like what we call the reasonable person test. So would a reasonable person have known about the risk that was present based on these facts? If you still are able to clear this hurdle and go on to question 2, then you would ask, was the risk not insignificant? Okay, so it wasn't something that was so small, that you wouldn't have to worry about. It's just something that almost certainly would not actually take place. It would not happen. Okay. So if it is not insignificant, so then there was a risk that you should have looked at and you should have done something about. Then we go to the third question, and that asks us that in the circumstances, so you're looking at every fact that you have about this case, in the circumstances, would a reasonable person, again going back to the reasonable person or the objective test, would a reasonable person in this position have taken precautions? So that's when we take precautions, when the risk is not insignificant, the risk is big enough, the risk is large enough to merit or to warrant that you have to actually address this risk. So how do you do that? So you consider things like the probability, okay, that harm would occur if care not taken. If, for example, we look at the risk of someone slipping in a supermarket. So you enter a supermarket, maybe the floor is wet, yeah, and there's then of course this risk of falling, okay, of slipping and hurting yourself, a physical injury. So the first thing you'd try to ascertain whether the risk is not insignificant, okay, and you would establish that by looking at how likely it would actually be how likely would this risk of injury occur. In the third step, you look at the probabilities now. Okay, if that risk of falling is not insignificant, so how probable now is the harm that could be caused by that risk? So if the risk is that you're going to fall, slip and fall, what would be the probability that if you slip and fall that you will hurt yourself? Okay, is it almost always that someone is going to hurt themselves when they slip and fall, or depends on the type of person that we're talking about? Okay, the elderly, for example, relevant to someone who's maybe a child, or maybe someone with certain body characteristics that may be too fat, and so on and so forth. The second thing you want to consider is the likely seriousness of the harm. Okay, they would be harmed. We know that they will be injured somehow, but what would be the seriousness of the harm? Okay, is it just that they're going to have some sort of a what are they going to have? Is it going to be a broken hand, for example? Are they going to break something? Are they going to die? Depending on where they're going to slip. So this is where you look at the seriousness of the harm that would result from this not insignificant risk. So first you look at the probability. How often? So is it more or less than 50%, for example? Is it 90%? The probability that the harm would occur. Of course, the higher the probability, the more likely that the question would be answered in the affirmative, i.e., would a reasonable person in the defendant's position have taken precautions. Then you have the third bullet, which talks about the burden of taking precautions to avoid the risk of harm. So now that we know that there's a probability, and that probability had a likely seriousness that we could quantify in a way, what on the other hand would be, or could have been, the burden, i.e. the money that the financial burden, the money that the supermarket, for example, in the instance that in the example we're talking about, how much would the supermarket need to pay in order for them to take precautions to avoid the risk of harm? Okay, so this all depends, of course, on how probable the risk is and how serious the harm is, but also how much would you need to pay in order for you to remove this risk of harm. So if you put some sort of a sign to indicate that the floor is wet, okay, how much would that cost you? Or to have a supervisor that goes through the supermarket regularly to check on what's happening in the aisles, and if they see something like a wet floor, they would take corrective or defensive measures to ensure that no one actually slips. How much would that cost? Okay. And you are able to quantify that as well. The last thing you have also to look at is the social utility of the activity that creates the harm. Okay. Sometimes you need to create this risk that's not insignificant in order for you to achieve a social utility. So, for example, there's this incident sometimes that's referred to in relation to fire brigades. You know, if you are going to a certain fireplace where there's fire and you have to intervene to stop further damage to the property or to physical injury to people, and because of that social utility, the benefit that you are trying to achieve by stopping the fire, you drive maybe you cut across traffic lights, and you might actually drive exceeding the speed limit and so on and so forth, and that in itself of course is not an insignificant risk, okay, even though the sirens and everything, but that's still not an insignificant risk. But the question here would be then the social utility. Does this is there a social utility in relation to what you're doing? In our case, for example, exceeding the speed limit, is there a social utility that the activity you're doing, basically trying to reach a place where you have to fight fire, or you have to save a person from the threat, for example, of death? Okay. Same thing happens with ambulances, for example. Whether this activity creates more social utility than the harm, basically the risk that would result, and of course the harm that could follow. There are also other principles a court must take into account. Okay, we're not going to go through these in much detail, but the reference to these again is for example, in Queensland is section 10 of the CLA in Queensland. Okay, and remember that all of these civil liability acts are available to you for free. Okay, they're free on the internet. You can access them, and you can search for the section 10, for example, and read the section and see what these other principles are. Okay, this would be useful, of course, for people who are looking for high distinction grades, to add that to your answer, especially in part B of the final exam in relation to problem solving questions. If you have now answered all of these three questions in the affirmative, so you have established that there was a breach, okay, D has breached their duty of care to the plaintiff, and then we start looking at the third element, which is whether the plaintiff suffered harm, suffered damages. Okay, so we talk about damage here. We talk about not damages in the sense of monetary compensation, but we're talking about damage in the sense that there was physical injury or economic loss or even mental injury, and so on and so forth. All right. Just quickly before we leave the second element, I want to mention something that's of use, which is known as res ipsa loquitur. And the discussion of res ipsa loquitur on page 141. This is Latin for the facts speak for themselves. Okay. So the idea here is that this is of course a rule of evidence. Okay, it can be used when the plaintiff would be faced with difficulty in furnishing direct evidence of negligence because they were under the control and management of the defendant at the time the injury took place. So it's a shortcut, if you like, in order for you to argue that what happened, the harm that the damage that was suffered would not have occurred had it not been for negligence on the part of the defendant. And you will find examples of res ipsa loquitur, okay, on page 142. It's important for you to always read the business tips, like for example on page 143. For example, it says risk management principles suggest that constant monitoring of the probability of risk, the seriousness of the consequences if something were to occur, and the opportunities for and costs of eliminating the risk. So these have to be something that, as a business manager, you need to always keep in mind. This is why you're being offered this knowledge and why you are taking this course. You need to know what your responsibility is in relation to managing a business when you are in a position of authority, to minimize, to understand this negligence issue and how it could arise and how it could affect your business, and how you can minimize the risks that could result from carrying out that business. Alright, let's then move on to our so again, this is the analytical structure we've just been discussing in relation to breach of duty. Okay, so the standard of care that's expected is that of the reasonable person. When you talk about the breach, you have to establish the standard of care that is required of the plaintiff, of the defendant, in order for you to establish whether the defendant has breached the duty of care. So if they come short of the standard of care, they will have breached the duty. So how do you establish the standard of care? This is a flexible standard. Okay, so it changes from person to a person, from circumstances to circumstances. Okay. The reasonable person. So who is the reasonable person? What do we mean by the reasonable person? So we mean that by the reasonable person, we mean that it's a person equipped with the same skills and expertise as the defendant. So as the defendant changes from case to case, you would expect that the standard of care is also going to change. Okay. So the question really becomes, what would the reasonable person have done if they had been in the defendant's position? Okay, so where the defendant is providing a professional service, so someone like, for example, a doctor, the standard is that which is widely accepted by peer professional opinion. And in relation to children, the standard is that of a child of similar age and experience. So as we said, the standard of care is flexible, and you can read more about that point on page 136. Notice that it may also be necessary to consider the characteristics of the plaintiff, okay, and determining the standard of care, which involves considering the skills and knowledge of the plaintiff, and whether the plaintiff is a child, or intoxicated, or a prisoner, or is infirm or elderly. Okay. So we talked about the Civil Liability Acts. I think we've talked about Section 9 as well, so we'll leave it there and proceed to the third step, which talks about causation. Okay. Note that the law is not going to recognize damages if the damage is determination of some benefit flowing from criminal or fraudulent activity. So you can't go and argue that I lost benefit or I lost profit, for example, resulting from sales of drugs, right? So it has to be something that's legal. Otherwise, you wouldn't be compensated, of course, for illegal activity. There's also the idea that damage would not be recognized if it's too vague. It's too vague. So too vague to be legally recognized. So you can't quantify how much to compensate you. While you are going to the court and asking for compensation, but you are not able to tell us, how much should be compensated. So there's no basically evidence to prove what would the compensation, or what should the compensation be. Or where the plaintiff cannot prove that any damage was suffered at all. Okay? So the plaintiff, first of all, must prove that damage suffered is recognized by the law, and that the damage was caused by the defendant's negligence, and that i.e., what we mean by that, the breach of their duty of care, and that damage not too remote in law to be recovered. Let's look at the next slide. P must show some link between the damage suffered and the defendant's conduct, and P must show that the defendant caused damages. That's the causation, what we mean, what we call factual causation. Okay, and that's also the scope of liability, which is of course the terminology used by the CLA or Civil Liability Acts today, which was under common law referred to as remoteness. There's also a rule that we call the egg-shell skull rule on page 147, which is simply a qualification to the requirement that the damage must have been reasonably foreseeable. We said that you have to have reasonable foreseeability of the damage, right? This comes when we talk about remoteness. But this rule simply says that a defendant must take the plaintiff as they found them. So a defendant will be liable for injuries suffered by a plaintiff despite the fact that the plaintiff had a pre-existing condition such as a medical condition. So going back to our supermarket example, someone slips and maybe this person has an eggshell skull, so when they fall their skull is shattered and they die. You can't go and argue that this person had a medical condition. You just take them as you find them. Okay? So even if the injuries are significantly greater than might otherwise have been in the case, you would still be held accountable and found liable for this harm and this injury. Now, remember that the rule applies only to damage of the same kind as that which was reasonably foreseeable. Okay? So you can have a look as well at the example that's given on page 147 in relation to something called the Ganser syndrome. The Ganser syndrome. All right. Let's then proceed to our last learning objective for chapter 5, which asks us to identify the defenses a defendant can raise in an action for negligence and their potential impact on damages paid. As we said, there are two common defenses: the contributory negligence defense and the voluntary non-fit injuria, which is Latin for voluntary assumption of the risk. Notice that at the bottom of the slide it says that apologies or expressions of regret. Okay, now apologies and expressions of regret will not be very helpful. As you will see on page 152, make an apology is no longer treated as a clear admission of fault, and hence the grayed out sort of bullet point there. An individual can generally now express regret in connection with any matter alleged to have been caused by them without it being construed as an admission of fault or liability. And again, the idea of contributory negligence is that if you have contributed to the damage that you have suffered, so if for example you slip on this wet floor, but when you entered this market you basically were busy looking at your iPhone, and because of that you didn't see that the floor was wet, and so you ended up falling and breaking your hand, then that would be considered as contributory negligence. Okay, so the damages then would be reduced proportionately. Okay, under civil liability legislation you could also have it reduced to 100%. So depending on what your actions were and how you are responsible for the damages that you've suffered, okay, that would affect how much you can receive in compensation. Okay, so whether the plaintiff failed to take reasonable care for their or safety, with the standard of care being assessed on the basis of the reasonable person and what they would have known or ought to have known in the circumstances. So pretty much the same analytical structure we applied to the defendant, okay, you would have applied to the plaintiff. So now we're looking at the plaintiff and what they have done and whether they should actually be paid compensation or not. If, however, you talk about voluntary assumption of risk, but first let me just say a few more things about contributory negligence. So if you want to establish contributory negligence as a defense, the defendant then must be able to establish that first, the plaintiff was at fault or neglect, the plaintiff's conduct contributed to the injury they suffered, and that the damage was reasonably foreseeable and was contributed to by the plaintiff's act. Okay, which is listed for you on page 149. Moving on then to the voluntary assumption of risk, and you'll find that it says specifically that there are certain types of risk that are either obvious or inherent. Okay, So the civil liability reforms to the law of negligence revived the defense of voluntary assumption of risk to a negligence action in general. Until these reforms, relying on voluntary assumption of risk as a complete defense in areas other than sports was very difficult, because it was to be established that the plaintiff had a precise knowledge of the risk, a full and free understanding, and voluntary acceptance of the risk. Now it's easier to establish this defense. Okay. For example, if you have an obvious risk, which is a risk that in the circumstances would have been obvious to a reasonable person in the position of the plaintiff, there would be no, you can invoke this defense, the voluntary assumption of risk defense, and that would mean that you would fail to recover any compensation. Okay. Now, whether a risk is an obvious risk depends not only on the particular facts of the case, but also on how those facts will be interpreted by the court. Okay. So in these instances, the plaintiff, okay, is presumed to have been aware of the risk. Something similar comes under what's known as inherent risk. Okay. So a person is not liable in negligence for harm suffered by another person as a result of materialization of an inherent risk. And the definition of an inherent risk is given to you on top of page 152. An inherent risk is a risk of something occurring which cannot be avoided by the exercise of reasonable care and skill, such as in a diving case. Okay, and you can read more about that on that page. So, as we said, how that affects what you will recover. If it's a contributory negligence defense, then the plaintiffs would recover only a proportionate amount of the amount that they went asking for from the court, because they would have to deduct whatever would be considered harm or damage, or damages that are suffered because of their own actions. If it's a voluntary assumption of risk, then you'll find that it is definitely a total defense and the plaintiff would not recover anything. And if there are no defenses, so the plaintiff recovers the full amount that they have requested. Alright, so that's the end of our lecture for chapter 5. Next we will start on chapter 6, and that's going to definitely be a continuation of what we talked about today in relation to applications of negligence to business. Thank you.